Hi, and welcome to What's the Tea in L&E. I'm Leah.
I'm Mike.
And today we're going to talk about retaliation. Mike, what is retaliation?
So retaliation is when an employee suffers some sort of adverse employment action after they engage in a protected activity, and that's a very lawyerly way to put it. But say an employee complains about harassment, and then within a short period of time afterwards, they're fired, they're disciplined, and they claim that their complaint, that protected activity, is connected to the adverse employment action. You fired me because I said that you all were breaking the law, something like that.
We've all heard it, right? This was retaliatory, vengeance in some way. Okay, so Mike, here's a scenario for you. A client is getting ready to discipline an employee or terminate an employee even, right, for poor performance. And before they go into that meeting, or they're getting ready, they're going to do it on Friday, and on Thursday evening, the employee reports harassment. What do we do?
This is one of the most common calls I get in my practice. And the immediate instinct is always, well, they knew the writing was on the wall, and they're just trying to make our lives more difficult.
They're trying to be untouchable.
Exactly. They're trying to put this protection, the shroud of protection around them. And because of that, the instinct is, well, this is not a real complaint. This isn't a serious complaint. And we've got all of our ducks in a row, and we want to fire him, and we're just going to do it. And that's the mistake. The mistake is not to treat the complaint seriously, even if every instinct in your body says, this is a joke.
Right.
This is just this problem employee creating more problems on their way out the door.
This is why we're letting them go.
Right.
Oh, wait, no, that's retaliation. That's retaliation.
Right.
Okay.
So you have to take it seriously,
Yeah.
even if you don't want to. You have to take it seriously, and what the complaint is really going to dictate the response.
So let's say it's harassment, right?
Right.
Do we have to, normally we would investigate harassment. So we already know this employee is done for, they're out the door. Do we even have to investigate it?
Right, because they're gone, so what does it matter, right? So the answer is yes, you do have to investigate it. And what you do with the employee is going to kind of depend, sorry for the lawyerly, it depends on what the complaint is. So if they have poor performance and then they complain that their manager is sexually harassing them, maybe that poor performance is linked to the potential sexual harassment. You got to look into that. And in fact, you may have to delay that termination decision while you do that investigation. It's painful, but it's a lot less painful than litigation, especially litigation where you find out after the fact, hey, there actually was something going on here. So
well, I had a recent situation where a client wanted to give an employee a final written warning. So HR and management set up a meeting for like a Monday morning, and on Sunday they received an email from the employee requesting FMLA leave.
Oh yeah.
And they were like, wait a minute. So now we've got to wait 12 weeks. This employee is entitled to FMLA. The employee had said that they were experiencing anxiety. It was impacting their job. So when can the client still needs to go forward with that discipline, right? The employee is entitled to the 12 weeks of FMLA. Do you recommend giving it to them before they go or after they go? I'm a little concerned about during it, but what do you think?
Yeah, so it is going to depend on the nature of the infraction. If it is something truly egregious, like a major safety violation, just go ahead and administer it. I prefer it to be before or after and not during.
Right, because then you could have an FMLA interference.
Exactly. But don't be shy to impose the discipline that you were going to impose originally if you can determine that it's not related to the complaint.
Right.
So, for example, this poor performance issue, okay, we've investigated it. There was no harassment going on in our best determination. You move forward with the discipline issue, but it makes it all the more important that you have it really well documented. You're going to get accused of retaliation. And the way you say it wasn't retaliation and was a legitimate non-discriminatory business reason, non-retaliatory business reason, is to show, the steps that you've gone through to establish that this did in fact occur, that the poor performance was not a result of any alleged harassment, and then you go ahead and impose the discipline, and you've done the investigation to protect yourself.
But it is a touchy situation because always you've got that perception of retaliation. So have good documentation, talk to employment counsel, and thanks for joining us on What's the Tea?
Thanks, everyone.